Yeah, I'm Larry Tribe. I guess my official name is Laurence H. Tribe, and I'm the Carl M. Loeb University Professor at Harvard Law School and Professor of Constitutional Law. Early in my career, I had decided that it was really important to write what people have called a treatise on constitutional law. Thousands of footnotes, very elaborate summaries of the whole history of the thing, useful mostly for lawyers and especially for judges, because there was a big gap. After I did that, lots of other people wrote lots and lots of things about the court, the literature of constitutional law and of the law of the Supreme Court, not only through law journal articles, but through wonderful blogs like SCOTUSblog and others, is ample. So there are ways of getting your hands on all the details of what's going on in the court. Journalistically, in terms of the general public, of course that's missing because the general public can't immerse itself in all of those details. The general public gets a kind of, well, I have to say it, pablum. They get these caricatures about conservative versus liberal, activist versus restrained, completely false cardboard cutout pictures of what the justices are all about. You'd never know from hearing a lot of that coverage and reading a lot of it that Justices Alito and Scalia are at one another's throats often on the issue of what's the significance of the original meaning of the Constitution. In one case about violent videos, Justice Alito asks from the bench to one of the lawyers, I think what Justice Scalia wants you to answer is, what did James Madison think of video games? Did he enjoy them? I mean, these guys do not agree on how to interpret the Constitution, nor do the liberals agree on a number of issues. Justice Sotomayor joined what are widely regarded as the conservative justices in striking down a price control regime for drugs and pharmaceuticals in Vermont on the basis that it dealt with information and gave the government power over who could communicate certain facts to whom, and therefore violated the First Amendment. Sotomayor and Breyer disagreed strongly in that. And when I notice things like that and realize that to an ordinary person in the public listening to all of this stuff about how we're certain that the court is going to be 5-4 on this because there are 5 Republicans and 4 Democrats, or the court is leaning very strongly conservative on something else, I realized that there was a gap. And there was a gap that hadn't really been filled. There are terrific books by Jeff Toobin called, a book like The Nine and The Oath that give a colorful picture of battles inside the court, but they're not so connected with the legal principles that the court is articulating and that shape our lives. So you can get the legal principles if you want to take a little time out, get a law degree, become a constitutional law expert. You can get the caricature if you just want to read the morning news. You can get interesting drama about the personalities if you look at some of the books that are written, but a book that brings it together in a way that is accessible for the public seemed to me to be badly needed. And the reason it matters for the public to care about all of this is that the Supreme Court changes our daily lives. It makes a decision and it affects whom we can marry. It makes another decision, it affects whether we can own a gun or whether the people in the shopping center where we go will have guns. It makes another decision, it affects whether the president can take the nation to war. I mean, these are momentous decisions. They shape our lives. In a democracy where we're supposed to be self-governing, we ought to at least be tuned in to what's actually happening and not just caricatures of it. And so I thought I could help do that by writing a book that was fun, that was accessible, that people like Doris Kearns Goodwin would say are a joy to read. That would help entice people to read it. And then how would they use that knowledge? Well, they would use it partly in figuring out what the court's decisions mean to them, where the future is likely to go, but also when the next vacancy occurs on the court. It might make more sense for people to focus on what really matters about the justices who are nominated by presidents and who are either confirmed or rejected by the Senate. What are we looking for? Are we looking for a person who fits some stereotype of a, quote, strict constructionist or an originalist or an activist? Or are we looking for something about the worldview, the outlook of the person, the way the person understands the Constitution based on that person's entire life and history? And I think a more informed public means a better appointment process, means a more intelligent confirmation process, means a court that is more responsive to the evolving American narrative about our Constitution. Well, once I got the idea that a book like this was needed, I wondered how I would go about doing it. I was in the process of working with a really brilliant research assistant named Joshua Matz, who was my top research assistant at the time, and who was also going to help me put together a course for undergraduates, Harvard College kids who wanted to learn about not details of constitutional doctrine, but thinking about the Constitution. And we worked together so seamlessly. I mean, there was a wonderful generational difference. I'm in my 70s, he's in his 20s. He sort of knew the lingo of the generation I was trying to teach better than I did. He was in touch with them. I was in touch with what I thought was a different array of issues and understandings. And because we worked together so well, we thought it might really be fun to try to write a book like this together. Well, it was fun, but it was unbelievably hard. I mean, it was hard partly because the subject is hard, partly because making it seem easy and understandable without talking down to people is a real challenge, and partly because I was busy teaching full-time and he was busy clerking full-time. He was clerking for Judge Etkin in the Southern District of New York, then for Judge Reinhardt, not thought to be a person who leaves you much free time in your life in the Ninth Circuit. He was about to go off to clerk for Justice Kennedy next year. We wanted to make sure that the book got done before he started clerking for Justice Kennedy in July of 2014, because it was absolutely critical that no one suspect that any of the information in the book was somehow inside information from within the Supreme Court. So that gave us a much more genuine deadline than most people have. I mean, when the publisher would occasionally raise the idea that, you may need another month on this chapter or another week on that one, we would typically say, well, there's only 24 hours in the day. I typically don't sleep much anyway. But one thing that has to happen is this book must be out by June 3rd. And by God, it came out on June 3rd. And the process of working with Joshua Matz on it was great. We would exchange drafts. We would exchange emails. He was on the West Coast. I was on the East Coast. He was a little bit surprised that I would send emails at 3 in the morning. I was a little bit surprised that he was still asleep at 10 in the morning, but then I kept forgetting that's 7 in the morning out there. And I'm sure we must have exchanged 100,000 emails and Word documents, and finally the book came together. It came together in a way that I'm very happy with, and I think Joshua is as well. Well, other books, I mean, there are so many different ones that I'm not sure what to say. Some books take 2 or 3 main cases and focus on them, like Obamacare, gun control, and perhaps Citizens United. And they try to tell a story about each one, how the lawyers found the clients, how the case found its way through the courts. Some books tell a story about a particular personality clash, Obama versus John Roberts, beginning with the flubbed oath of office, in which I felt so strange here. 2 of my students in constitutional law, and they aren't even getting the oath of office right. But big secret, I don't think I ever asked them to memorize the oath of office. This book is organized around a kind of different principle. We wanted to touch on every major area that the Roberts Court, each court being named after the Chief Justice, just somewhat arbitrarily, that presides over the court during that time. Roberts became Chief Justice in 2005. There were lots of really important cases during the period from 2005 to 2013. We didn't want to leave any of them out. There were important cases dealing with free speech and politics, important cases dealing with, of course, Obamacare, but not each in isolation. Obamacare, just for example, is a case not only about the limits of federal power to regulate people, but also about the limits of federal power to tax people, and about the limits of government power to make people do what's good for them generally. And that connects to principles of libertarianism, economic liberty, that are important in other areas of the court's decision-making. So when we would take a case like Obamacare, we would embed it in a chapter, in that one, I think we called it the healthcare cases, liberty on the line. We would talk about all of the interconnections that the existing literature just didn't talk about. And in the chapter on Citizens United, which we separated from the chapter on free speech, we would talk about the relationship between money, political power, and free speech, and the dangers of government deciding who may speak and who may not. In that one, we called it Citizens United, Follow the Money. The point is that each chapter took a case or two or three, not so many as to become hard to keep track of, the most important cases of the Roberts Court in every area, from free speech through equality, through gun rights, through federalism, through access to justice, and then an important additional topic that none of the books talk about, the topic of bargaining away your rights. It's something that the court has begun to grapple with. You know, there are a lot of ways the government can get people's rights. It can put a gun to your head, and it can coerce you, perhaps into confessing, perhaps into pleading guilty. There are limits on coercion. But what if it just tempts you? What if it just bribes you? Are there limits to how government can bribe you? That, it seemed to me, was an important thing that none of the popular writing about the Supreme Court examined carefully, and something that the Roberts Court has paid a lot of attention to in some interesting cases, including cases about AIDS, about prostitution, about all sorts of subjects that are kind of intrinsically colorful and interesting. But the frame of it all was the inadequacy of caricatures about the court. That's why we call it uncertain justice. Everybody seems certain of their own views of the court. You know, there are these people who are certain that people on the court are just politicians in robes. There are others who are certain that politics doesn't make any real difference. There are people who are certain that they have a way of predicting decisions. We are uncertain, and we think uncertainty is inherent in the nature of what the court does and the problems that it confronts. And we think that uncertainty is not necessarily a terrible thing. We think it can be cleared up to some extent, but we think it is the uncertainty that people need to understand. And so we begin and end the book by talking about the nature of uncertainty in the law and, frankly, in life generally.